Hi, I'm Greg Dell here with attorney Stephen Jessup, and today we want to talk about what it takes to win a Prudential disability denial lawsuit. Stephen, you've handled hundreds and have reviewed thousands of Prudential disability denial letters that have been sent to you, and claimants all over the country have called you. But there's a lot of things that go through your mind when someone calls you, because every single Prudential disability denial has its own sets of facts and circumstances and are different. Denial letters tend to be the same because Prudential writes I don't know, it seems to me it's always like the same three-page.
It's a template.
Yeah, it's like a template, the same 3 pages, they go through the same motions. But the person watching this video now has been denied, and they don't know what their options are, what's it going to take for them to win. So let's go through that a little bit, and starting with the first thing when they approach you and say, how can you help me and what do you need from me in order to try to get my benefits paid again?
Yeah, so in a matter of a lawsuit, generally when they contact, we need to see the denial letters. I do like to see a copy of the appeal that was submitted. That's at a bare minimum of what we need to see: the initial denial, the appeal, and then the final denial. But that's just really scratching the surface. To really get an understanding of likelihood of success in court, you're going to need see the whole claim file as well to be able to do a deep dive into that.
So a lot of people call right away. They say, Prudential called me on the phone, which is something they do, and say, I've lost my appeal, they're not going to pay me. What should be in that final denial letter that's going to help you evaluate whether or not it's a case that you think is winnable?
What should be in it? Well, it's always an interesting thing, what should be in a denial letter. Usually when I'm looking at the denial letters, I'm wanting to see at the very least the information that was provided on the appeal, because they'll generally talk about what they reviewed, what they saw. Also want to see the level of review that Prudential did. Did they send the person to an independent medical examination? Were it just file review doctors, and if so, how many? So kind of getting an idea of what information we're going to have to work with, because after a final denial on an appeal, no new information comes into the file. So we are bound by what's going to be in the file at that date to determine what our likelihood of success in court is. And a lot of people, it's just a weird area of the law, and it's not that, hey, I just have to show to a judge that you're disabled, and there's argument with regards to this next part, but ultimately I also have to try to show the judge that Prudential was arbitrary and capricious or acted unreasonable in their denial. So it's a situation of not just showing that they were wrong, but they were unreasonable in doing it, and that's a very, very hard threshold for a plaintiff to try to meet. And you can usually get an idea of how much the cards are going to be stacked against you in the final denial.
Yeah, and I want to highlight something you just said about once someone contacts you and that final Prudential denial is done, there is nothing else we can add to that record, which means that if they call you and say, yeah, I got denied yesterday, and today I found out that I actually got an MRI and I have a fractured cervical vertebrae, that evidence does not come in. Prudential will not consider it, and they're not required to consider it by law. So that goes to the importance of getting everything and anything into the appeal. And often people contact us and we do the appeal, but we also have a fair amount of people who do appeals on their own or had some other law firm do it, and then they call us because they want us to file a lawsuit for them. So we end up becoming married to what's known as the claim file or the administrative record, and that's the other thing that you said. So the denial letter, the final denial letter, is just a little summary scratching the surface as to, hey, here's why we denied you, but everything that we relied upon is in this claim file. So what do these claim files typically look like that you get from Prudential?
Normally, you can talk, depending on how long the person was on claim, the amount of medical, you can see thousands and thousands of pages, and there are going to be all the medical records, correspondence, throughout the whole time, claim forms that were submitted, their own internal SOAP notes. That's all the internal notes from people at Prudential and their discussions, reviews, any vocational reports, surveillance reports, doctor reports that they had done, IME reports. So it's everything. Like this area of the law, we've said in so many times in videos, it's very pro-insurance. But one of the at least positives in it is that they do have a duty to turn everything over. So you're not waiting, months down the road into litigation to have any understanding what you're dealing with. You can get that information. So you can start, prepping the file to put it in a light most favorable, for the client.
So what I want people to understand is that we get the denial letter, initial free consultation on the phone. We look at it and go, okay, I think maybe there's something here we can help you with. But the reality is we really need to see your claim file, which you said is thousands of pages, and we need to dig into that. From there, obviously we want to see the policy. And when we look at the policy, we determine what's the standard of review that we're going to have at court, because there's de novo review and there's arbitrary and capricious review. And to keep it super simple for people, if it's de novo review, then just the judge is going to make a determination whether or not he thinks the person's disabled or not. Some states follow the de novo review if there's no discretionary language in the policy, which means the person's policy has language which says that Prudential has the right to interpret the terms and conditions of this policy and they're the payor. If that language is in there and it's valid, then the judge has to say, first of all, do I think the person's disabled? And if the judge gets to that decision, then the judge has to say, do I think, even though I think the person's disabled, do I think Prudential acted reasonably? And if Prudential acted reasonably, then the judge has to affirm the decision, even if he thinks the person's disabled. People listening to this are probably saying, what are you talking about?
Yeah.
The judge just found that I'm disabled, but finds that Prudential acted reasonably. And this is the most screwed up area of law that exists in our, probably, in our entire civil world of laws, because this is how the industry wrote these particular ERISA regulations in an effort what was to basically try to protect the policyholders, but really what it did is it allowed companies to write cheap policies and then write cheap policies because it made it more difficult for people to collect down the road, because the benefit of the doubt is given to the insurance company. So we set the stage for people to help understand that if there is this discretionary clause, which more than 75% of the policies have, and more than 75% of the states allow discretionary language, then we know we have a harder battle than if we're dealing with a straight review up to the judge. So I wanted to make that clear. But how do you then deal with this? Assuming whatever the standard of review is going to be, how important is it for you to have a mastery of the case law and apply that to the facts of the case that you're being asked to try to win?
I mean, it's really the only chance to win, right? I'm always of the opinion that 90+% of the time, I'm confident that medical information will support disability. Now, we do see it sometimes where it's just not good medical, and you don't know if you're going to pass that first hurdle, but more often than not, I think we can get past that hurdle. So it's always looking down to this idea of the reasonableness, in the review. And courts aren't going to come up with that on their own. They're going to look to the case law to make a determination. Is there precedent? Have courts in this jurisdiction and other jurisdictions had similar situations? Heck, have there been similar situations and denials and fact patterns in other prudential cases that the court can then rely upon and say, well, it's similar to this one. This is why I disagree with what they did here, and whatnot. So the case law really is the ultimate authority in what you're going to do. And federal judges, they're not trying to reinvent the wheel. They're not trying to come up with some new argument. They're going to go by that case precedent. And when you do see sometimes judges, go away from the set precedent, often they get overturned in appeals on that stage. And most judges, I've done this long, don't like to be overturned on an appeal, getting that reprimand of sorts of, hey, you got this wrong. So they're just going to fall in line with what the case law out there is. And I think there's one more nuance in this area of the law. Unlike state courts, state judges could be in a criminal courtroom, a civil courtroom, they stay in separate lanes. Federal courtrooms, we've been in status hearings where you'll hear, multi-defendant, large RICO criminal defense claims, big tort actions, and then here comes an ERISA case where the judge is like, wait, I don't have to take testimony in court? I don't have to do discovery? I don't even have to see the attorneys, you're just going to file motions? So I think that they don't necessarily, see these ERISA cases as something that they give a lot of attention to. They just look at what the law says, and then they'll have their opinions written to just fall in line with what the preceding case law has to say.
Right, so I think the key at the end of the day to winning this is first you got to prove, you got to be able to dive into that multi-thousand page claim file, pull out all the facts that are in support of disability, and really hope they're there. I know if we do the appeal, we know they're going to be there, and we handle thousands of appeals every year. But if someone contacts us and they've done their own appeal, we don't know until we do a deep dive into there what's there. The other thing we don't know is what did the insurance company doctor say. We will know once we get in there. So the first thing is we got to convince the judge medically, this person's disabled, judge. The next thing is they acted unreasonably, assuming there's an arbitrary and capricious review, which, 7 out of 10 times there is. But to keep it positive and not make it as dreary as it sounds, it is rare that a judge finds, I find the person disabled, however, I find the company acted reasonably. To me, that's more of a human nature thing, that if you're the judge and you find, yes, the person's disabled, then judge, how could you find that the person's disabled based upon the review of the evidence, but then at the same time say, they reviewed the same evidence as you, and you think they acted reasonably? It doesn't happen a lot because they supposedly looked at the same information. And that all comes down to the argument that we make in our motions to the court. And you touched upon the fact that there's no testimony, there's no jury trial. It's all about the submission of this, what basically ends up coming to either a trial brief or a summary judgment motion. And it's extensive writing back and forth, usually limited to 25 pages each side, plus a reply. And it's intense for us because lawyers, we want to, if we had our way, we'd submit 200 pages. Court's like, you got to get everything and anything in 25 to 30 pages. And that's it. Now the judge, so people understand, are supposed to review the thousands of pages that we reviewed, because the judge gets the claim file and the judge gets these motions. You know, does the judge go through the thousands and thousands of pages? Arguably the judge is supposed to, but it comes down to these briefs. So you really got to have a lawyer who's done this time and time and again, knows how to do it. Last thing I want to touch on is we talk about what it takes to win, but a win can be defined in many different ways. And so not every case goes to the hands of a judge for a final decision. As a matter of fact, you know that 95% of all federal lawsuits, not just what we do, settle. And a settlement can be considered a win. So talk about how the majority, the high majority of these cases end up getting resolved.
Yeah, I would say overwhelming majority of them. Most courts will mandate mediation. So there'll be at least a one day there's going to be a formalized sit down between the parties to try to get it resolved. So that's always going to be there on the table. And even prior to that, Prudential generally through their counsel, they'll even be looking to see if there can be resolutions prior to that date. Even in situations where I've reviewed files and I've had an honest assessment with the client and say, listen, the likelihood of us prevailing in court is very, very slim. I still know that we can get, in mediation and negotiations, they're going to put money on the table. There's always, I tell everyone, you've got nothing to lose in pursuing this. Your legitimate worst case scenario is exactly where you are, them not paying you. Now, yes, there could be, if Prudential wins, they can go after a person for attorney's fees. Very rare. The times I've seen attorney's fees awards awarded to an insurance company is when there was some implication of insurance fraud, like there was almost like a punishment thing. So realistically, your worst case scenario is exactly where you are now, them not paying you. So it's always worth pursuing, because we've had people like, I'm just tired, I don't want to keep dealing with this. And it's just a matter of, if you stick with it, there is going to be some level of positive outcome. Now, any settlement, it's a compromise. The client's generally not ecstatic, the insurance company's not ecstatic, but when you take, the risk reward and, analysis in there, the majority of these cases will settle. And the insurance companies, even if they firmly believe in what they did was the right call and the right decision, they're going to have their defense attorneys that they hire, get those marching orders, hey, see if we can get this one resolved. Now, resolutions and settlement amounts, that can vary. Also, the stronger the case, the more risk to the insurance company. Usually we see higher percentages of value in settlement and all that type of stuff. So again, that's a whole nother analysis to determine what this case may be valued to an insurance company, and then within that number, how much they may be willing to pay to try to resolve it.
One of the things that our law firm, from doing this for so long and having proven to Prudential that, hey, we'll go the distance with you, and we've won on multiple occasions, is there's been a level of mutual respect for our law firm, and we're able to file a lawsuit and in a relatively reasonable amount of time get to a mediation or some kind of settlement conference to say, we don't have to kill each other, crush each other, spend thousands and thousands of attorney's fees on both sides. We'd rather more money go to the client. Can we get this resolved early on? And if we can't, then we'll go to battle. And so that's a big advantage that we're able to offer here for a claimant, is to say, let's get money on the table for you. If it's something you're willing to take, we'll get it done. If not, you got firepower behind you. We're going to go the distance. But we're going to tell you honestly, you got a 50% chance, an 80% chance, a 10% chance to win this thing. And so if it's a 10% chance, likely you're going to want to settle even if you don't like the numbers. If it's 50-50, it's all up to you. So it's a business decision at the end of the day.
Yeah.
So if you're someone out there with a Prudential disability denial, feel free to reach out to myself, Stephen, or any of our disability attorneys. No matter where you live in the country, we're available to assist you, and we look forward to the opportunity to speak with you.